Anytime the judge is getting ready.
Yes, sir.
What did he say?
Well, I'm not sure how much is different.
With Atkins and attorney visit,
Mr. Knoll, you ready?
I am, Your Honor.
full shingle ready.
Who are you ready on?
Judge, first is Dakota Pfeiffer. I think all of these are on the,
This is CR 20, that'll work. CR 2266, State versus Dakota Anthony Pfeiffer. I show that we are set for pre-trial today. Go ahead, Mr. Knoll.
Judge, I actually received an offer, a new offer yesterday. It's kind of connected with another case in another county. In fact, the assistant DA handling the case here talked with the assistant DA handling the case in Wood County. We're trying to resolve hopefully both issues. I think one more pretrial will either resolve or set this matter for trial.
Like, set it for next week?
For next week for,
Well, you said reset it. I'm saying how long? Next week?
Depends on, I'm set on the 14th, 16th, and 18th in other counties. The court wanted to set any of those, I think that's a Tuesday or Thursday slots, I'm fine, but, or set it on the 12th when everything else is set, either way. Probably need a little more time than that to figure out what we're doing.
What's the issue?
I need to talk with Mr. Woodwick again. He's reviewed some stuff and he actually changed his offer to a better offer. I think there's one more issue that I need to speak with him about.
All right, I don't want to set it off another 30 days while Mr. Pfeiffer's in jail. So I'm going to set it for next Thursday, the 17th. Since you're telling me that you think you're close to resolving it, I'd rather go ahead and try to get it resolved rather than let him sit for another 30 days. So we'll set it for docket call on 12/17 and then find out where you're at that time.
Thank you, Judge.
Mr. Shannon? We'll take him outside. Yeah, I just got
Judge, I think they have my next one coming in. It's Chad Adkins.
Okay. You ready on Mr. Atkins?
I am, Your Honor.
All right, CR 2237, Mr. Atkins also set for pretrial today, I believe.
That's correct, Judge. Judge, well, I guess first thing is Mr. Adkins was arrested I think, on 2 warrants that involved parole issues, but he was also arrested on December 2nd on a additional drug charge. I would like to have the time to, I guess, visit with the state to see what we can resolve as opposed to just take care of one issue at a time. This arrest, I don't know that the DA's office even has a case file on the most recent arrest, but maybe we can get rid of all cases.
I'm just kind of assuming here that you're talking about this new charge being a Van County charge?
Yes, Your Honor, it is. It was a PCS arrest, Grand Saline PD.
And when was that arrest?
I'm sorry?
When was that arrest?
December 2nd.
And what's the alleged charge on that?
PCS, penalty group 1 between 1 and 4. And it could come down below 1, depending on, my guess is they weighed the substance as they usually do within the container that they found it in, which may drop it below 1 gram.
Okay. Do you have any contested pretrial motions on this case?
Not at this time, Your Honor.
Okay. Then we'll set this case for docket call on January 12th. We'll let the other case take its course.
Thank you, Judge. I'll have him sign a reset now. Ready for the last case I have is Mr. Gutierrez, and I'm sure he'll be in here shortly.
Okay. Bailiff, is Mr. Hyde there?
Judge Bailiff stepped out, but at this time, Mr. Hyde's not there.
Okay. Thank you, Mr. Rainey.
Really, really bad.
No, not as bad as, not as bad.
All right, CR 2050, State versus Jesus Humberto Gutierrez, set for pretrial today, Mr. Noel, go ahead.
Judge, I think this is a fairly new appointment. I met with Mr. Gutierrez Monday. There are actually several witnesses that need to be contacted regarding this matter. I've actually made some efforts on my own, no luck so far. I'd like to put this matter past, if possible, the January 12th date so we can attempt to contact the witnesses, not only to this incident, but to apparently some incidents or an incident that preceded this incident. Mr. Gutierrez has filed a motion to reduce his bond. Present bond is $150,000. I don't believe he has any criminal history other than possibly traffic tickets. We request that the court consider, he's already indicted, obviously, to consider a reduction to possibly 20,000.
Okay, you're gonna have to back up and explain that to me again. You filed a motion to reduce his bond?
No, Your Honor, he filed his own motion. I don't know. I think I have a copy of that.
Is Mr. Gutierrez representing himself now?
He is not, but he filed it. I assume he filed it before he realized that there was a indictment. I'm not sure about that.
Before there was an indictment or before there was you appointed to his case?
Could be before I was appointed to the case. I don't actually have a date of the filing of his motion, but I think it actually was prior to me being appointed to the case.
Are you wanting me to set that for a hearing?
Yes, and I've tried to call a witness, but I've gotten no response on the issue of the bond. But if the court could set that for a hearing, maybe on the same date we've set Mr. Pfeiffer on the 17th.
Has that motion been provided to the state?
Judge, I have no idea if when the defendant files a pro se, if the state also gets a copy. I would assume that they did, but if not, I will get them a copy.
Your Honor, it's not in our file. I don't have access to the e-file, but I'm assuming that a pro se would also not have access to the e-file. So I don't presently see a copy in our file.
So, Mr. Knoll, I'll let you file a motion to reduce his bond. And once you file that, give notice to the state and request a setting. And I don't want to set it until it's been filed with the court.
Other than that, Judge, we just need to, I'll wait till I get that filed, obviously ask the court for a setting on that. And then because I think there's going to be witness issues, I'd like this, if possible, put off towards the end of January as opposed to January 12th. I'm already having problems with people responding to a simple phone call.
All right, court will set this for docket call. There being no contested pretrial matters, set for January 26th.
He said, January 26th. Well, it says defendant. She's never called back. Or your brother. That's all I have, Judge. May I be excused?
Yes, thank you, Mr. Knoll.
Appreciate you, Knoll. Appreciate you, Judge.
Good afternoon, Judge.
You too.
Judge, we're ready on Mr. Raspberry.
This is cause number CR 20190, State versus Coleman Raspberry. Mr. Raspberry set for plea today. Are we entering a plea?
That's correct, Judge.
Okay. And if someone from the state can tell me the terms.
Judge, she's muted. If you'd like, I can
Judge, I gave my hard copy of the plea paperwork to Mr. Manning, so I will let him read the terms so I don't get them wrong.
Okay,
Judge, our plea is to a plea of a lesser included offense of possession of controlled substance, penalty group 2, less than a gram, and then we're going to proceed under 1244B with punishment assessed at 15 days in the county jail with credit for 1 day, a fine of $3,175, court costs, and a fine to be paid at the plea, $180 restitution, 1245 unfiled misdemeanor M1900374.
hang on, you're going a little too fast for me. M19 what?
M1900374,
Okay,
which is possession of marijuana.
okay. How much are the court costs? Court costs $290?
$290, and total his fine and court cost altogether are $3,500. My client has that here in cash, but I realized once he rolled up that we don't have a clerk here to take that. So if the court would like, we can make some arrangements to either convey that to the bailiff or somehow get that cash back to the clerk's office.
Is this, so this is for time served?
No, Judge, he'll be serving 14 additional days going into custody today.
Yeah, I don't want to put that on deposit with the bailiff. Give me just 1 moment.
Okay.
All right, we are back on the record. Cause number CR 2190, State versus Coleman Raspberry. Mr. Manning, if you will take possession of that money, then a member of the clerk's office will come to the jail and pick that up. They will not be able to issue a receipt at the jail. However, they can issue a receipt once they get it back to the office and process it.
Yes, Judge. I will be here for a little bit longer, so I can do that, and I'll leave the receipt in Mr. Coleman's possession, or Mr. Raspberry's possession.
Well, there's not going to be a receipt until they get back to process all of that. That means it'd be probably after the close of the docket, so that I can sign the judgment and give it to the clerk. So it may be at the end of the day or tomorrow. But the clerks indicated they could send a copy out to the sheriff's office to put in his property, and we can also send you a copy.
That will work, Judge. Thank you.
Let me repeat back to you what I heard the plea to be so that I'm clear. He's currently charged with a second-degree felony PCS PG2 400 to 400. However, the plea would be to a lesser included PCS PG2 less than 2, prosecuted under 1244B, 15 days confinement in the county jail, credit for 1 day, $3,175 fine, $290 court costs, $180 restitution, 1245 unfiled possession of marijuana M19 374. Is that correct?
That's
Yes, Your
correct.
Honor.
Okay. All right, Mr. Raspberry, at this time, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can put your hand down. Just make sure you speak up as loud as you can so my court reporter can take it down and so that I can hear you, okay?
Yes, Your Honor.
Mr. Raspberry, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes, Your Honor.
Have you ever been diagnosed with any type of mental condition?
No, Your Honor.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, Your Honor.
You feel like you've had sufficient time to discuss your case with him and have all of your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've reviewed and signed today that you do not understand?
No, Your Honor.
And where your signature appears throughout the documents, are you attesting that that is your true and correct signature and you've only signed once the documents have been explained to you or reviewed and understood by you?
Yes, Your Honor.
Mr. Manning, do you believe Mr. Raspberry to be competent today?
He is.
And have you explained to him his legal and constitutional rights?
I have.
All right, Mr. Raspberry, to the charge of the lesser included charge of possession of a controlled substance in penalty group 2, less than 2 grams. How do you plead, guilty or not guilty?
Guilty, Your Honor.
And Mr. Raspberry, are you pleading guilty because you are guilty of that offense and for no other reason?
Yes, Your Honor.
Has anyone threatened you, forced you, or pressured you to plead guilty to this charge?
No, Your Honor.
Court will accept Mr. Raspberry's plea of guilt. Mr. Manning, any objection to States 1?
No objection.
States 1, the stipulation of evidence is admitted into evidence. Court will also take judicial notice of Mr. Raspberry's judicial confession. Is there anything further from the state,
No, Your Honor.
from the defense?
Rest and close.
Ms. Heisel, will you give me just a brief summation of the evidence supporting Mr. Raspberry's plea?
Yes, Your Honor. Mr. Raspberry was one of 4 young men traveling in a vehicle that was pulled over for a traffic offense. Mr. Raspberry was a passenger in that vehicle. He was not the driver. Some clues led the officer to questioning the inhabitants of that vehicle, and 3 of the 4 boys, including Mr. Raspberry, each claimed a bag as their own that all contained different forms of THC edibles. Mr. Raspberry, the lab weighed one of the substances that was sent to the lab that was contained in that backpack that Mr. Raspberry claimed possession of was a THC brownie that came back about 61 grams of THC, Your Honor.
Mr. Manning, any objection to that summation?
That's a correct summation.
All right, the court, based on the evidence, finds that there is sufficient evidence to convict Mr. Raspberry of this offense. The court will follow the plea agreement in this case. The court hereby convicts Mr. Raspberry of possession of a controlled substance in penalty group 2, less than 2 gram. Assesses his punishment in accordance with the plea agreement and also under section 1244B of the Texas Penal Code at 15 days confinement in the Van Zandt County Jail. Court issues Mr. Raspberry 1-day credit for time already served. Court assesses a fine of $3,175. Court cost of $290 and restitution of $180. Court also considers under Section 1245 unfiled possession of marijuana M19-00374. Mr. Raspberry hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I will have you step to your left to be fingerprinted by the bailiff. And Mr. Manning, you said that Mr. Raspberry is going into custody today. Is that correct?
That is correct. He's going to custody as we speak.
Thank you, Mr. Manning.
And Judge, I believe we're also already on Mr. Hall.
Mr. Manning, were you appointed or retained on Mr. Raspberry?
I was appointed.
Does any of the money collected today address your attorney fees?
No, Judge, the agreement was for fine and court costs to be paid up front. I've told him that he needs to make arrangements with the court's collection officer once he gets out of jail after he's served his sentence.
Okay. Is this Mr. Michael Hall?
Yes, Judge.
All right, this is cause number CR 2251, State versus Michael Carl Hall. And I believe that we are set also for a plea today. Is that correct?
That's correct, Judge.
And who has the terms?
Again, it'll be Mr. Manning.
I can read them off, Judge.
Please do.
So he will be proceeding under the second-degree felony of possession, controlled substance, penalty group 1, 4 to 200 grams. The finding of guilt will be deferred and punishment assessed at 5 years community supervision, $3,500 fine, $180 restitution, and there'll be a 1245 for possession of marijuana, less than 2 ounces.
What's that number on that POM?
I was not given a number on that one.
Judge, it's DA 2020-45.
And court costs?
Court costs in this case are going to be $290.
All right, Mr. Hall, if you will, raise your right hand. Mr. Hall, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
All right, you may put your hand down. Mr. Hall, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, Your Honor.
In this case, you have your attorney with you, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, Your Honor.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've reviewed and signed that you do not understand?
No, Your Honor.
And do you tell the court today that anywhere that your signature appears in the legal documents that is your true and correct signature, and that you've signed that attesting to the fact that you understand what you're signing?
Yes, Your Honor.
Mr. Manning, do you believe Mr. Hall to be competent today?
He is, Judge.
Mr. Hall, at this time, how do you plead to the second-degree felony offense of possession of a controlled substance, penalty group 1, 1 gram to 4 gram? And let me tell you what the range of punishment on that is. The range of punishment for that type of offense, being a second degree, is confinement in the Texas Department of Criminal Justice for a period of not less than 2 years or more than 20 years, and a fine not to exceed $10,000. What that means for you is that if the court approves this deferred adjudication plea and places you on probation, if you violate it and there's proof given to the court and the court adjudicates your guilt and revokes you, the court could sentence you anywhere within that range of punishment, from as little as 2 years to as much as 20 years, and fine you up to $10,000. Do you understand that range of punishment?
Yes, sir, Your Honor.
So at this time, how do you plead to that offense?
Guilty, Your Honor.
And Mr. Hall, are you pleading guilty because you are guilty of committing that offense?
Yes, Your Honor.
Has anyone threatened you, forced you, or pressured you to plead guilty to that offense?
No, Your Honor.
All All right, court will accept Mr. Hall's plea of guilt. Mr. Manning, any objection to states one?
No objection.
States one is admitted into evidence, and the court takes judicial notice of Mr. Hall's judicial confession. Is there anything further from the state?
No, Your Honor, we'd rest and close.
On the defense,
Rest and close.
Ms. Heisel?
Yes, Your Honor. Mr. Hall was the driver of a vehicle that was stopped for no front license plate. Immediately, the officer is able to see a marijuana grinder in plain view in the vehicle. He asks Mr. Hall about the presence of drugs in the vehicle based on the plain view. He tells him he's going to do a probable cause search. Before he starts searching the vehicle, he asks Mr. Hall to empty his pockets for officer safety, and Mr. Hall hands him a box that contains marijuana and 4.25 grams of methamphetamine, Your Honor.
Mr. Manning, any objection to that summation?
No objection, Judge.
All right, then based on the evidence, the court will find that there is sufficient evidence to convict Mr. Hall of this offense. The court will follow the plea agreement in this case and defer a finding of guilt at this time. We'll place Mr. Hall on community supervision for a period of 5 years. The court assesses a $3,500 fine, court cost of $290, orders Mr. Hall to pay restitution of $180, and the court considers unfiled possession of marijuana DA 2020-45. Mr. Hall, you were in court on Tuesday, right?
Yes.
And you're here today because you're in custody today because you were found to be in violation of your conditions of pretrial release on Tuesday by the court. Is that correct?
Yes, sir, Your Honor.
So, Mr. Hall, I'm wondering if I place you on community supervision, are we just delaying the inevitable, or are you going to be able to comply and not do cocaine and methamphetamine or marijuana or anything else?
Will comply, Your Honor. I will be able to.
And you understand that you're looking at up to 20 years in prison if you don't.
That's right.
Do you have a family?
Yes.
You have kids?
Yes.
You have a wife?
I have a girlfriend, a long, steady girlfriend. So,
All these people rely on you?
yes, I do, Your Honor.
Do you provide for them?
Yes, I do.
You understand that if you violate the terms of your community supervision, they're going to have to find someone else to rely on and provide for because you won't be there for them. You understand that?
Yes, I do.
So if you're not going to do it for yourself, you can at least do it for them. Wouldn't you agree?
Yes, you're right. You're definitely right.
All right, Mr. Hall, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can to the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I believe Ms. Burns is there. I'm going to have you step to your left to be fingerprinted. Once you're released, before you leave that room there, I want you to speak with Ms. Burns. She'll give you further instructions on when to report to the probation department, Mr. Hall.
Thank you, Your Honor.
You're welcome.
Your Honor,
Yes, ma'am.
we've got Ms. Cassell with the clerk's office here. Would the court allow us a few minutes to complete this transaction so that we can get this on its way back to the courthouse?
Yes, ma'am, absolutely.
Okay, thank you, sir.
Thank you.
Mr. Yes, sir.
Mr. Manning, are you ready on Ms. Odom?
Yes, we are, Judge.
All right, court call CR 20-186-187, State versus Courtney Michelle Odom. Set for docket call today. Is that correct, Mr. Manning?
That's correct, Judge.
Go ahead.
Judge, I've gone over the discovery extensively. I've spoken to Ms. Odom about that discovery. I've received an offer that I've conveyed to her. We weighed that offer. We've discussed it, and she would request some additional time for me to discuss some counter offers with the elected DA, Ms. Curry. So at this time, we would announce not ready on the docket call.
Any objection from the state?
No, Your Honor. Understandable.
Mr. Manning, about how long do you believe you need to make your counter offers?
Judge, if we can just have a standard reset for up until January.
All right. Court will reset for January 12th. Do you have any conflicts on that day, Mr. Manning?
No, Judge. Okay, so this it's a problem. January 12th. Judge, may she be excused?
Yes, we'll see you back on January 12th, Ms. Odom. Bailiff, I believe I saw Mr. Hyde there earlier.
Yes, sir. He's back in the room, Your Honor.
Okay, I believe I have his client to appear via Zoom in the online waiting room. So let me go ahead and pull him in. This is going to be Mr. Martinez, I believe. Let's see.
No, yes, that's right.
It says Mr. Martinez is still connecting the audio. Mr. Martinez, if you can hear us, please raise your hand. I've lost video. Mr. Martinez, if you can hear us, will you raise your hand? Sent Mr. Martinez a message to find his microphone.
You want me to call him?
You're going to be able to walk him through how to turn on his audio?
We'll try. Hey, you need to turn up your audio. You need to turn up your audio on your phone. Can you hear us? You can hear who clearly? No, I'm talking about on the video. On the video, you need to.
We can't hear him.
Yeah, it's you. Everything's good except for your audio. I think you need to turn it up on your phone. There should be a little
If it
button.
stimulates the screen, there ought to be a little red microphone.
There should be when on your, it says I think he's on a phone. You're on your phone. There should be in the bottom corner a little red microphone or something for you to tap. All right.
Hello?
There you go. That's it.
Okay. Sorry about that.
Okay, all right. Court call CR 19-181, CR 25-4, State versus Cruz Martinez. We were set to enter a plea before the court today. Is that correct, Mr. Hyde?
That's correct, Your Honor.
And it's come to the court's attention that Mr. Martinez has tested positive for the COVID-19 virus. Is that correct?
That's correct, Your Honor.
All right, Mr. Martinez, then the court's going to reset your date to enter your plea. Mr. Martinez, when did you receive your COVID positive?
Yesterday, Your Honor, according to the document. Yesterday morning.
All right, the court's going to set Mr. Martinez to enter his plea on January 7th. Do you have any scheduling conflicts that day, Mr. Hyde?
No, Your Honor. And this is a jail plea, so we'd be at 1:30.
Any objection from the state?
No, Your Honor.
All right, Mr. Martinez, you're ordered to be at the Van Zandt County Justice Center on January 7th at 1:30 to enter your plea before the court. Do you understand?
Yes, sir.
And this will be the
Yes,
only
sir.
this will be the only notice you receive. We're not going to mail you anything or call you or do any of those things. I'm telling you right now in open court, January
Okay.
7th at 1:30 at the Van Zandt County Justice Center. Okay? You understand? Mr. Cruz or Mr. Martinez has lost his audio. Mr. Cruz, Mr. Martinez, can you still hear me? Raise your hand if you can hear me.
This is on the screen.
Okay. You understand you got to be here on January 7th at 1:30. Raise your hand if you understand that. Okay. All right. You're free to go. We'll see you on January 7th. Mr. Manning, is this is this Miss Jody Denton?
It is, Judge.
All right. I show that we're set on a hearing on her motion to revoke.
Yes, Judge. I just got appointed on the motion to revoke. I've been previously appointed in the new offenses. I have not received indictment or discovery on those offenses as of yet. And those are the main allegations in the motion to revoke. At this time, I've gotten our PR bonds on her new cases, but she has a no bond on the motion to revoke. I haven't had an opportunity to discuss with the state maybe a possibility of getting a resolution on her case, whether that's through a plea or some type of bond. I'd be willing to talk to him. This is my first time to be speaking to Ms. Denton on her motion to revoke, as it was just filed after my appointment.
How long have you been on the other case?
I've been on the other cases since September the 11th.
And when was Miss Denton indicted?
She hasn't been indicted on the new cases yet.
Oh, she has not. Okay.
No, I got PR bonds and then didn't realize that she had a motion to revoke filed after I filed those PR bonds.
Okay, then the court will set Ms. Denton for a hearing on her motion to revoke on January 12th. And if there's some kind of resolution reached before that time, then you'll just notify the court. We'll make arrangements one way or the other.
Yes, Judge.
This is only back on January 20th. Ms. Denton, be excused.
Yes, you're excused, Ms. Denton. We'll see you back on January 12th.
And Judge, I believe that concludes my business. May I be excused.
Yes, sir. Thank you.
You Judge.
How you doing?
Your Honor, we're just waiting for Mr. Michael Salazar to be brought up. He is on the way.
Please call me Heath. I don't want to be that old yet.
Yes. Hello again, sir. Step right on up here with your.
Here, sip here.
All right, what are the terms on Mr. Salazar's plea?
4 years TDC, Your Honor.
On what offense? And I need specifics. I need court.
Okay, it's cause number 1700341, assault of a household member with a previous conviction. It was a third degree, 2 to 10. He was probated, 10 years confinement, probated for 4 years. And the fine was $2,310.65 with court cost of $117.35. And we've reached an agreement of 4 years confinement in TDCJ, and there's 92 days of jail time credit.
Thank you, sir.
Correct. And Judge, just for the record, those fine and court cost amounts that Mr. Hyde read out, that is his balance of financial obligations. That was not the total of the original obligation.
Okay. Ms. Heisel, is the state proceeding on its motion to revoke file August 17th?
Correct, Your Honor.
All right, Mr. Salazar, if you will, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
There.
All right, you may put your hand down. All right, Mr. Salazar, you appeared before the court on June 30th of 2020. You pled guilty to the offense of assault of a family or household member with previous conviction. The court heard the evidence and assessed found you guilty and assessed your punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court suspended that sentence and placed you on community supervision for a period of 4 years. It was during that period that the state filed its motion to revoke community supervision, alleging in one count that you violated the terms and conditions of your community supervision. Mr. Hyde, is it your client's intention to plead guilty to that or plead true to count one?
Yes, Your Honor. We'll waive reading of the information and enter a plea of truth.
All right, thank you, Mr. Hyde. All right, Mr. Salazar, I'm going to share my screen here for you. Mr. Salazar, I'm having shown to you on the screen count one of the state's motion to revoke your community supervision. At this time, Mr. Salazar, how would you plead to count one in the state's motion to revoke? Is that count true or not true?
True.
And Mr. Salazar, are you telling me that the count is true because in fact it is true and for no other reason?
Sir.
And Mr. Salazar, has anyone threatened you, forced you, or pressured you to plead true to that count?
No, sir.
All right, the court will find that Mr. Salazar's plea of true is voluntarily given at this time. Mr. Hyde, is there any objection to the admission of the defendant's waiver of rights and plea of true as State's Exhibit A?
No objection.
State's Exhibit A is admitted into evidence, and the court takes judicial notice of Mr. Salazar's judicial confession. Is there anything further from the state,
No, Your Honor, we'd rest and close.
from the defense?
Rest and close.
All right, and based on the evidence before the court will find that Mr. Salazar has violated the terms and conditions of his community supervision. The court will also follow the plea agreement reached between the defendant and the state. The court, having found that he has violated his community supervision, hereby revokes that community supervision, assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice Institutional Division. The court awards Mr. Salazar 92 days for time served on this sentence prior to today. The court also orders Mr. Salazar to pay the balance of his financial obligations. Mr. Salazar, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'll have you step to your left to be fingerprinted with the bailiff. Good luck to you, sir.
Sure. Thank you.
Your Honor, I believe that's all I have.
Thank you, Mr. Hyde. Good to see you.
I don't think I'll see you before Christmas. Merry Christmas.
You could just mail that gift or bring it by, whatever you want to do.
It should be delivered already.
All right. You might want to call your package delivery.
I'll check on that.
Have a Merry Christmas.
All right. No, sir, I just.
We're good. Hey, good luck to you. Yeah, thank you. All right, thanks. You too.
Bailiff, do we have just one left?
Yes, sir, he is on the way, Your Honor.
All right, thanks.
What? Going around.
Hillary.
Yeah.
This is what you did.
Deputy McLeish, is Brent Gimbel there in the jail with you?
Don't, have you seen Mr. Gamble? No, ma'am.
Okay, thank you.
Yes, ma'am.
All right, Mr. Lunsford, you are Jerry Wayne Lunsford, correct?
Yes, sir.
All right, Mr. Lunsford, I show that you are incarcerated on a charge of possession of a controlled substance in penalty group 1, less than 1 gram. That's a state jail felony offense. It carries a range of punishment of not less than 6 months or more than 2 years. Do you intend to hire an attorney to represent you in this matter?
No, today I put in for court appointment.
When did you put in for that?
I just put it in for today.
Okay, so you filled out the paperwork while you've been there in court,
Yes, no, before I came to court.
but it was today.
Yeah, I turned it in today.
Okay. All right, so I'll tell you what, just have a seat and I'll be with you in just a moment, okay?
That look like this?
Yes, ma'am, I filled out, the lady that brought me in here, she just now I gave it to her.
Okay.
She said, turn it in.
Okay. We might fast track it a little bit.
Yeah, I turned it in today. I can't go home now.
That he's doing that now. Yes, sir. If it's back there, I'm gonna I'll take whatever you have.
It may be out by 3:30 anyway. Is it not for bench?
No,
No.
no, James is gonna bring that paperwork back and I'm gonna try to send it to Judge.
Okay,
So we're still working with it.
okay,
Thank you. Doing okay today?
Yes, ma'am, I've been trying to get to the nurse. I have heart problems. I've been having a little pain in my heart. So I've been trying to get back there for the last 3 days. They said it's coming, but I don't know if it's seeing. But, other than that, I'm doing pretty good. I'm hoping that I can talk them into giving me more probation. I did 4 years. Extended or something. I'm not a criminal. I made a mistake.
Where you from?
Alaska from Willis, Texas.
Willis?
Where's
Willis?
It's up there near Houston.
How free at Conroe?
Oh, wow.
8 miles from Colorado.
You?
My mom, my wife, we have a niece. We've been staying with people and they've been kicking us out and all this. So my niece gave us a trailer to live in. So that's where I'm living right now, in the trailer. Finally got elected on, the wife wrote me, told me she got the lights on. Just trying to live life, man. This corona's got everybody down. And then right on top of it, my wife broke her hand when she writes with, so if we do surgery on it, I'm here.
Ms. Burns, can we scan an email from that?
No.
Well, that was quick. We'll see how these.
No hesitation on that part.
Exactly.
Y'all got me back there with these other guys, and they over here with charges on, golly, man, I'm like a little infant back there with these professionals. Kind of get a little nervous. Anxiety comes up, boy. These dudes got assault charges and all kinds of crazy stuff. I ain't nothing like that. I try to be the nicest guy I can be, because I wouldn't want nobody to treat me bad, so I treat everybody with respect. I just want to go home. I'll pay more for breakfast, whatever they want to do. I did those 4 years. I was almost done.
Hang on just a second, Mr. Hunt.
We'll get Terry to probably scan it and stuff, whoever.
Well, we're not gonna, he asked for a screenshot and I sent that. So I believe he's reviewing it right now. We need to scan it. If he can't bring it, I'm sure he'll let us know. I just thought since the machine was in here, I thought it did that.
I'll have to ask him see if he can set that up.
What you need, Mr. Casper?
This goes 2 bills to pay.
Oh. Yes, sir. Maybe you do that.
That's all that was in her deal. All right.
Not really.
Well, they don't have to drive, man. It takes an hour to drive one here to Carroll.
We shouldn't have to go get him.
Mr. Lunsford, if you'll step back up. All right, Mr. Lunsford, the court has reviewed your application for appointed counsel, and it appears at this time you meet the guidelines for court-appointed attorney. So the court will appoint an attorney, and we're going to bring you back on Thursday of next week, December 17th, and that'll give you a chance to meet with your attorney. We'll appoint that attorney today and notify them. They may be in contact with you tomorrow or the first part of next week, but we'll bring you back on the 17th and have a discussion again about your case once your lawyer gets involved, okay?
Yes, sir. Thank you.
All right, so my bailiff's going to have you sign a form here, just says that we're going to come back on the 17th. It is for a motion to revoke.
This is your copy of that. May he be excused, Your Honor?
Yes, that'll be all. We'll see you next week, Mr. Lunsford.
Thank you.
All right, State, I think that resolves our afternoon docket.
Judge, I had a question. Mr. Gimbel had filed motions for bond reduction for both the McGahee and Hansard case. We've already taken care of McGahee, but I didn't know if the court had scheduled Hansard on a different day or if he had withdrawn that.
Can you spell that last name for me?
It's Hansard. I was under the impression they were both set this afternoon, but I very easily could have that wrong.
Ms. Heisel.
Yes, Your Honor.
Ms. Tabraham says she had a conversation with Mr. Gimbel, and Mr. Gimbel indicated that he was not aware that his client had been indicted. But he also did not do a non-suit or request to withdraw the writ. Was the writ filed? I guess a writ was filed, but we do not show it to be set today.
Okay.
Not show it to be set at all, actually.
Okay, thank you, Judge.
Anything else?
No, that's it. Maybe we be excused.